Hello, I'm Tommy Cresswell. Welcome to the ERG Manager's Toolbox, a video series from Employers Resource Group. These programs are designed to help managers and supervisors deal with the increasingly complicated laws and regulations that govern the modern workplace. In this program, we'll look at harassment in the workplace.
Come in, Charles. Hello, Charles. Come in and join us, please. Sit down. Charles, this is John Finucane from our law firm. And this is George Warrington, our senior vice president who flew in from headquarters this morning.
We just received this, a complaint, a lawsuit filed against the organization and you for $485,000. It alleges harassment and was filed by a Miss Laura Bell.
I can't believe this. She's only been here a couple of months.
Mr. Shandon, this is a $500,000 lawsuit by someone who works for you. Now, you are named personally. Now, she claims she suffered harassment and you were aware of it and didn't do anything about it.
Mr. Shandon, this could prove to be an extremely difficult case for the organization. There are some very upsetting allegations here.
What do you have to say, Charles?
Well,
Harassment in the workplace can cause severe problems, both for the organization and for individual managers and supervisors. In this program, we'll give you some basic information on how to deal with harassment, and we'll talk with some legal experts about how anti-harassment laws affect you. We'll help you understand why you should be keenly aware of these issues, and we'll show you how to handle and prevent harassment problems. An easy way to think of harassment laws is to picture a sardine. The letters stand for sex, age, race or religion, disability, invasion of privacy, national origin, and emotional distress. Sardine is an appropriate acronym for harassment because if you don't deal with it quickly and properly, a sardine can get very nasty, and that should be your attitude toward any form of harassment in the workplace. Now let's look at sardine. S is for sexual harassment, and there are two types of sexual harassment. The first is called quid pro quo sexual harassment, which occurs when a supervisor demands sexual favors in return for job benefits.
The obvious example that to avoid, and one that has been avoided, I think, for some time now, is the sleep with me or you'll lose your job threat. That is so obviously illegal that I don't think you run into situations like that anymore. Everybody knows that's wrong. The gray area now is where a male manager asks, perhaps innocently, a female subordinate to go for a drink, and perhaps she can't because her schedule is crowded. And perhaps later on her work deteriorates and she's disciplined or discharged. She may think that her failure to originally accommodate his social request is sexual harassment. That's a gray area, and I think the advice for managers is to treat all of your subordinates in social requests even as equals on an equal basis. If you ask females for a drink, you should be asking males for a drink too.
The second type of sexual harassment is called hostile environment. Some examples of this include unwelcome touching, unwelcome comments about a person's clothing or body, sexually oriented jokes told in the workplace, lewd pictures or objects displayed openly in the workplace, comments reflecting hostility based on gender, such as indicating that women should not be allowed to perform a certain category of job, obvious unwanted attention of various kinds, such as leering, whistling, and even email.
Virtually any words or conduct of a sexual nature that are either unwelcome or offensive can be considered sexual harassment. Now, the majority of our cases deal with males harassing females. We have seen cases involving females harassing males, and increasingly we've seen allegations of same-sex harassment.
A is for age harassment. Federal civil rights laws protect workers age 40 and over, and some states have broader laws that may protect almost anyone against discrimination on the basis of age.
Well, most managers fail to realize that even the most innocent comments can come back to haunt them down the road. Comments such as, we're looking for younger people with new blood, can be used as evidence to taint an otherwise legitimate employment decision months and sometimes even years later.
R is for race. Racially based comments or jokes are always inappropriate. But there are other more subtle forms of discrimination as well, such as differences in work assignments, how promotions are determined, and the behavior of coworkers. As a manager, you must be very observant about how your people work together.
You might not hear any inappropriate comments, but you might notice that a minority employee is often alone and typically moves away when certain other co-employees are around. And that may be a sign of a problem. And you should take the time to monitor the interactions between the employees in that work group more closely.
R is also for religion. An employee's religion or sincerely held beliefs are protected under the law. Problems with religious discrimination often occur because of employer dress codes or when employers require work on a particular day.
Some religious groups require unusual clothing or hairstyles. And in those circumstances, you should not allow any employees to harass those individuals because of their unusual dress or hairstyles. And furthermore, there are some groups which require conduct which may violate your company policy. For example, if your company has a policy of working overtime on Saturdays, and the religious group forbids work on Saturdays, you may have to accommodate that particular individual's religious beliefs.
D is for disability. The Americans with Disabilities Act defines disability very broadly. It's obvious that someone who is paralyzed has a disability, but there are many more employees who can be considered disabled.
The hardest disabilities to deal with, and ones that we're seeing more and more of, are mental disabilities. Those are extremely difficult to deal with. Someone in a wheelchair has a mobility impairment, that's pretty clear, and how an employer accommodates the person in a wheelchair is fairly easy to do for most employers. We can't expect, although the EOC and in some cases the courts require us to, our supervisors to be amateur psychiatrists. We can't require someone to recognize multiple personality disorder. I think mental disabilities are the most difficult ones to deal with right now.
I is for invasion of privacy. Employees often sue for an invasion of privacy based on a supervisor's conduct. This can include questions about an employee's private life or conduct such as appearing unannounced and uninvited at an employee's home.
Well, recently, a jury in Texas awarded a woman $100,000 based on her employer's search of her locker without her permission. The best way around this is to put employees on notice up front that their lockers or other personal belongings are subject to search if they're brought on the employer's premises. And perhaps the best way of accomplishing this is by giving the employee an acknowledgement form and asking him to sign it up front.
N is for national origin. This issue can arise if someone is teased a lot about their accent or the way they dress. And E is for emotional distress. This can be a part of an employee's lawsuit when they claim they have suffered severe emotional distress as a result of harassment.
With the enactment of the Civil Rights Act of 1991, which now provides for compensatory and punitive damages, emotional distress claims have increasingly become a part of employees' damages claims. And these claims arise in either race, sex, age, disability, all types of lawsuits. There is also a state law component known as intentional infliction of emotional distress. And to prove that, employees have to show that they were subjected to extreme and outrageous conduct which caused them severe emotional distress. With the addition of compensatory and punitive damages, these types of claims are much more costly for the employer. You can get hit with much bigger damages awards by a jury.
Unfortunately, it's a fact of life that some employees may file charges no matter what you do. The best plan you can follow to reduce the risk of a lawsuit for harassment is to treat people the way you would like to be treated, with professionalism and respect. But your good example's not enough. You must also make sure your employees are not harassing each other. Remember, you and your organization can be held liable for harassment between co-workers. Here's an all too common situation.
Hello?
Do you have a minute?
Well, sure, Laura. Come on in. Sit down.
This is very difficult for me. But since I started working for the company, Art in accounting has been making nasty comments about Asian people. And, well, he tells jokes. And yesterday, he started joking how I should start doing his taxes because everyone know we're good at math. It may be a joke to him, but I'm tired of it. It hurts.
Here's the situation. Laura is a new hire in an entry-level administrative position. Art has been with the company for 10 years, and he's known as kind of a kidder, but he's an intelligent, hard-working employee. What do you do?
Laura, I want you to know that we take all harassment allegations very seriously, and I plan to look into this immediately. I will try to be as confidential as possible, but I'll need to investigate the circumstances thoroughly. I'll get back to you as soon as I can. We have a very strict anti-harassment policy here, and I want you to feel free to talk to me or to any of the other managers.
Thank you.
Hello, Human Resources, Blanche Amory.
Hello, Blanche. Charles Shannon here. I've got a problem that I'd like to discuss with you as soon as possible.
My next hour's free. Can you stop by now?
Great. I'll be right down. Now, Art, I know that you've been with the company for many years, but your comments and jokes toward Laura are inappropriate and must stop immediately. Now, behavior of this sort will not be tolerated in the future, and if you do indulge in this sort of behavior in the future, disciplinary action will be taken. That's up to and including your discharge. Do you understand? If you could sign this for me as a record, please. Laura, I have investigated the situation and I've talked with Art. Now, he's assured me that this behavior will never happen in the future. But if you do experience this again, I want you to come to me or one of the other managers immediately. Now, are you satisfied with the way we've handled this?
Yes. Thank you, Charles.
Now, let's review the key elements to dealing with harassment complaints. First, take all complaints of harassment seriously and assure the complaining party that the organization takes all complaints seriously. Secondly, ask for help. Your Human Resources Department or legal counsel are valuable allies. Next, respond to the problem promptly. We cannot overemphasize the importance of a prompt and serious response to harassment complaints. And document your investigation and response. Documentation is vitally important.
Perhaps the biggest mistake I see with my clients is a failure to document promptly, consistently, and thoroughly. The biggest way to get in trouble is to fail to document the problem up front, because down the road, when these items turn into litigation, the first thing the jury's going to want to see is a piece of paper documenting the incident.
Remember, if you notice harassment going on, you have a duty to act on it. You must do something about it, even if the person being harassed doesn't complain. You have a duty to act because you, and therefore your employer, are now on notice that there is harassment at the workplace. You should respond the same way you would if someone complained. Take it seriously, ask for help, respond, and document. These simple procedures will help you manage a quality workforce and should be a part of every manager's toolbox.
What do you have to say, Charles?
Laura came into my office and informed me of the situation. As you can see from my memo, I met immediately with Blanche in HR, and we began an investigation. I spoke with people in the department on a confidential basis, and then I met with Art. I told him that behavior of this sort would not be tolerated. And then I met with Laura and informed her of the results of my investigation and urged her to come to me or one of the other managers if any more harassing behavior occurred. She said that she was satisfied. And since that time, she has not complained to me or to any of the other managers. It's all right here in the file.
This is very good work, Mr. Shandon. I think this is one case that is decidedly in our favor.
Thank you, Charles.